Punam, in the case of Schofield, Mr Justice Mostyn refused an application under Part 3 because, as he described it, the army pension was a paltry level of income. How did he come to that conclusion?
Schofield was a very interesting case. In that case, the husband and wife were both British nationals, but the husband had been stationed in Germany by the army for some years, and he'd been accruing an army pension. By the time the parties came to divorce, they only had £78,000 between them in terms of capital assets. The wife was working only part-time in a pharmacy shop, so her income was very low. And they divided the capital assets between them. They just needed the judge in the German court to make that order, which he did. But then the judge said that he wasn't able to deal with the husband's army pension, which actually was quite significant because the husband was entitled to a £40,000 lump sum, and the cash equivalent transfer value of the pension was £280,000. And the judge, in essence, said that he wanted the wife to go off to England and apply for an English pension sharing order in respect of the English pension because he didn't have any jurisdiction to deal with it. And so he, in effect, severed that claim and asked the English court really for cooperation to deal with that part of the wife's claim, which is what the wife did. So she went off to England, applied to the English court for leave under Part 3 for a pension sharing order in respect of this pension. Now, the case came before Mostyn, and he said that he was not going to grant her leave for two reasons. One, he said that, as you said, it was a paltry level of income. But secondly, he applied the gloss on the Agbaje decision that he had already designed in the case of CG and IF in 2010, whereby he said that the applicant had to show a 50% or better chance that they would succeed in their eventual application in order to get past the leave stage.
Now, although the pension was described as paltry, in fact, in terms of the overall assets, it was quite significant, and so the wife appealed. What did the Court of Appeal decide?
Well, Lord Justice Thorpe was actually quite scathing of Mr Justice Mostyn, and he said that Mr Justice Mostyn was wrong to apply the gloss that he had done in CG and IF, that the words that he should be applying are the words of Lord Collins in Agbaje, which was that the wife had to demonstrate at the application for leave stage that she had a substantial or a solid case, and that's all that she needed to prove. And the case is important for public policy considerations because the German court had asked the English court for collaboration, and in this case the English court did help. The English court dealt with the English pension sharing order as it should have done, and that's why it's an important case.
Now, you mentioned the threshold that needs to be crossed in making a claim under Part 3. How was that approached in CG and IF?
CG and IF was actually one of my cases, and in that case Mr Justice Mostyn attempted to amplify the substantial solid test as proposed by Lord Collins in Agbaje, and what he said was that the applicant making a leave application had to show that he had a 50% or better chance of getting his application through at the end.
So what about cases where there is a pre-existing agreement, either on jurisdiction or on finances?
Well, that would be Traversa and Freddie, where it was a kind of prenuptial agreement, but it wasn't, because it was just a matter of two Italian nationals getting married in Italy, and they had to decide which regime they were going to get married under. And they could have community of property, they could have separation of assets, or they could have no regime at all. And they opted at the time of the marriage for separation of assets.
So what was the financial award here?
Well, in this case, the wife applied to the Italian court for a divorce decree. So she got a divorce decree, and in 2004, the divorce court handed down a financial agreement, which was that the husband was to pay maintenance to his wife for the two children, and he was to transfer the matrimonial home into her sole name. So it was only 4 years after that, that when the husband actually was served with notice to quit on the former matrimonial home, that he applied under Part 3 for leave to make a financial application in England. And this case was heard by Mr Justice Bodie, and at that time the Court of Appeal decision in Agbaje was current, and that refused the wife's application for leave. So Mr Justice Bodie was merely following the precedent, and he refused the husband's application. And in the meantime, the Supreme Court decision of Agbaje was handed down, which of course reversed the Court of Appeal decision, and therefore the husband applied for leave to appeal out of time against the decision, and Lord Justice Thorpe said he could demonstrate a substantial ground and therefore granted his leave application.
And of course, in Traversa and Freddie, there was an argument about Brussels 1. What was the conclusion there?
Yes, this is actually quite complicated because there is a distinction under Brussels 1 and also under Lugano between maintenance, as under the regulations, and also rights arising out of property. And under Brussels 1, if you already have a maintenance order in another jurisdiction, then jurisdiction number 2 cannot then deal with maintenance because it's already been determined in that first jurisdiction, and therefore they would have to, the second court seized would have to decline jurisdiction, grant a mandatory stay, and have the first jurisdiction deal with it. So in this case, what the Wives' Council was saying was, well, this is under Brussels 1, therefore, because there's a maintenance element to it, and therefore it's already been adjudicated upon, and the court now, the English court, had no jurisdiction to deal with it. And Lord Justice Thorpe said that Brussels 1 expressly excludes from its application property transfers under a divorce. So in this case, he said that what had happened in Italy was in fact a hybrid order, and he said that the property part of it was severable for the maintenance. Only the maintenance is capable of enforcement under Brussels 1, and the court therefore in England had jurisdiction to deal with the property transfer. He said that Mr. Justice Mostyn was wrong to fix the element of capital in Italy just because the maintenance had been dealt with there.
So really, Punam, there's quite a lot to think about here. I can see the potential for things going wrong. Have you got any practical advice?
Yes, I think for Part 3 applications, and I've done quite a few of these now, I think first and foremost, get good specialist advice from counsel. I think we know what the test is now. It's solid, substantial. That's what your client has to show in order to get over your leave application hurdle. If you are going to make your leave application, it must be made ex parte. Lord Justice Thorpe said that the statute was clear and it was not for us practitioners to fiddle around with that and give notice the other side. So we were told very clearly we have to make our applications ex parte. If there is at all an element of maintenance, you need to be very careful. You've got to consider Brussels 1, Brussels 2, the applicability of the Lugano Convention, and also, of course, the new EU maintenance regulation that came in this year, 2011. So there's a lot to think about. Have a look at the Red Book for jurisdictional matters, but above all, as I say, take advice early and be aware that these are expensive and time-consuming applications.